Okay, so today we're going to be talking about how to build your AI contract review playbook. I'm Electra, I'm the Chief Legal Officer here at Law Insider, and I have been supporting many clients with the creation of their playbooks. Playbooks are, we're going to talk about all about them today, but they are they underpin your legal operations in a world of AI, where you're utilizing AI to review your contract in accordance with your preferences. I think there are a lot of myths around playbooks, and there's not much transparency as to what they are and how you can actually build them to make them work. So the aim of today's webinar is to be very hands-on, very educational, and please drop any questions or comments that you have in the chat or the Q&A at any time. This is all new, and I have been doing in my previous role, where I had a legal consultancy, a legal ops consultancy, I used to build playbooks in Excel for a living. So we used to do loads of these big playbook projects, and they were really hard. And clients would have to engage for weeks on end in order to do them. So I have a very in-depth understanding of how playbook rules work. But then when it comes to creating AI rules, that will translate the intention of a playbook rule, that's a completely new world. And I have learned so much over the last few months while I do this work. So, you know, even for those of us that are really deep into this, this is all completely new. So I just want to emphasize the last bit here. There are no silly questions. This is all new to everyone. So if you have any questions, please ask them. It also helps the community. We've built an amazing community here at Law Insider, and everyone's sharing knowledge. And these webinars are not just for me to broadcast to you, but also for you to share knowledge within this community. So if you have any insights or anything that you found out recently around this topic that you think is interesting, please share. Okay, we're going to start off with a poll. So Dory is in the background, as usual, the Wizard of Oz of these webinars, and she will be launching a poll now. And the question is, do you use playbooks to review your agreements? Yes, an AI playbook. Yes, a document. A document might be an Excel spreadsheet or a PDF or a Word document or notes that you have. So anything that you have actually documented is used as a playbook, either just by you or across your team if you have one, or no, all the rules are in my head. So yeah, if you could just take a second to answer this, that would be really helpful in setting the scene for today. We're going to give this a second so that you guys can answer, and then we will display the results as well. And I also understand that, you know, not everyone understands the concept of a playbook and what it means. And there are many different things that we use the word playbook to describe them as. So it's okay. So yes, an AI playbook, 14%. Yes, it's a document, 34%, but the majority has all their rules in their head. Okay, great. This is really, really interesting to see. And thank you to everyone who took part in that. When it comes to a world of AI, this is really what's the impetus for us progressing in this industry and getting AI to do the things that we have done manually for years. I think the biggest barrier to that will be us trying to take out the things that are in our head, the institutional knowledge, the instinct, and codifying that. So if you have documented it in AI, amazing, you're in the minority. If you've documented it, that's great, because that's the beginning. And if you have not documented it, you will have to document it, because that's the only way that you're going to be able to take advantage of the enormous advancements of AI technology. And, you know, it's not helpful when we see stats like these. So recently there was an MIT study that showed that 95% of AI pilots fail. I think this was just, you know, clickbait, really, this kind of title. If you delve deeper into the report, and for anyone who's watching this or anyone who receives this recording later, we're going to circulate the slides, and there's a link here to the study. So if you want to delve deeper, you can do that. But basically, if you read closely, it's not the AI, it's the implementation. So the AI is not the problem. The implementation of AI is the problem. And unfortunately, there's just not enough education around how we take AI tools and implement them properly. And so again, implementation for AI contract review equals playbooks predominantly. If you have codified your rules and you know what it is that you're looking for, then AI can help you. That's not to say that AI contract review tools can't help you with general review where you don't have rules, but if you really want to supercharge what you're currently doing manually, pulling out those rules that you have in your head and codifying them in a playbook is what's really going to supercharge your contract review processes. And so for today, the objectives are to give you a clear understanding of what AI playbooks can do for you, the difference between your own party and third-party playbooks and why that matters, because there is nuance as to whether when you're creating a playbook to review your own paper, that's a very different tool to when you're using a playbook to review third-party paper. And I'm going to talk about that difference today. How to structure your rules, including fallbacks, so that they're clear and enforceable, and how to write prompts to the AI to tell it when to redline or suggest or escalate issues automatically. And of course, I want to give you the ability to build consistency and confidence across your contracts. If you're thinking, I'm never going to use a playbook because I only review ad hoc agreements and I don't have enough volume of one type of agreement in order for me to create a playbook, you can create a general playbook that you use that will also help you to streamline the way that you work. Because whether you're doing this consciously or not, when you're reviewing a contract, you're almost always applying very similar rules. So the capability to take those out of your mind and put them into an AI tool is really what's going to help you streamline the way that you work with the use of AI. Okay, so failure or success. I think that there are a lot of misconceptions around playbooks. And when I get on calls with prospects or customers who are looking at the law inside a word add-in, I think that there's a general misconception around the process of creating playbooks. And lots of people, I'm going to say the majority of the people that I talk to, say to me, I don't have a playbook, but I have a template. Can you take my template and create a playbook from that template? Because if you read my template, then you'll be able to know, you instantly understand what my positions are across various provisions, and you should be able to translate those provisions into rules. I'm going to talk in detail as to why that's an insufficient process. You can go a little bit further compared to you not having a template at all, but it's not the best way of doing it. So when you're relying on templates or precedents instead of playbooks that are purpose-built, you will never get the results that you would get if you actually did the work. When you're writing your rules and you're not clear, either because you're not clear as to why you're doing something when you're doing it manually, or because the way you've expressed it isn't clear enough, then what the AI does, because it's very clever, is it guesses what you mean. It doesn't go, sorry, I didn't get that. It guesses what you mean. And what happens as a result is that you will get disappointing results. So an important skill that we're all going to have to develop is writing clearly for the AI. When you don't have any fallbacks, that's fine. Some people are just like, this is my rule and take it or leave it. But if you do have fallbacks that you are applying when you're reviewing manually, then it's important to bake those into your playbook so that you can mirror real life negotiations, and you've got a tool that's going to support you beyond just, your preferred position. Lots of people treat third-party paper like their own. They don't really differentiate between first and third-party paper, or own paper and third-party paper. I'm going to talk about that in a minute, as I said. They are fundamentally different types of documentation. When it's your own paper, you're really controlling the narrative, you're controlling the drafting, you're controlling you might have approved wording as to what might go in and what can come out. So there's just more rules around your own paper. Some people might just say, look, just treat my own paper like third-party paper and take a more principles-based approach. I'm not going to go into detail now because I don't want to overwhelm you with that. I'll go into it in detail in a minute. And then lots of people perhaps don't fully appreciate the importance of testing and iteration. So when a vendor like us will deliver a playbook to you, or when you create your own playbook, don't expect it to work first time. all you can do in the beginning is set out your rules and get the AI to look at those rules and then implement them into your contract. But as you do more and more reviews, you might find that actually the AI is not exactly picking up what you need it to, in which case you need to be comfortable enough with going into the prompt and iterating on the prompt in order to make it better. And if all this sounds overwhelming and like it's a lot of work, it is a lot of work. It takes work for you to create a really good playbook. And I don't want to downplay that. I think that when you're buying tech, lots of vendors will say, yeah, sure, you can just run the AI over your document and it will create an automatic playbook for you. And then you're disappointed as a result. It's not that simple. You will need to put in some work. Firstly, to extract the knowledge that's in your head, to put it into a way that's documented and structured. And secondly, to test that the AI is doing what you need it to do, not with just one or two use cases, but as you continue to use the tool in everyday scenarios, you want to make sure that those prompts are doing what they need to be doing for you. I'm going to just pause there to see whether there are any questions. Dory, is there anything that I need to be addressing at this stage?
I think there was one question around in terms of legal definitions and understanding. Would you recommend then writing a general rule in your playbook to ensure a broad understanding or a very detailed one, but with the risk of too narrow thinking? And I think we're going to get to that, but want to just address that one.
Yeah, let's get into that in a second, because I'm going to be talking a lot about how you structure things and how to get the most out of your tool. And I think it depends on your preferences as well. So you might have a personal preference where you want the AI to just flag some stuff to you and you want to be very hands-on. So you just want the AI to pinpoint where something is and then you can take a look, rather than have the AI do more of the heavy lifting, which is to actually surgically redline. And so for that reason, it depends on your objectives. I quite like very granular rules because I think it mimics what we do as lawyers more. So the broader your rule, the more of a lift on your end. The more narrow the rule, the more granular the output will be. So my preference is make them as granular as possible. I will be getting to a definition of playbooks now. That was handy, just to the last question. Okay, so what's an AI playbook? So it's your operating system that powers AI to review like you would. Now, that doesn't mean that AI playbooks are going to replace you. There is still a huge human in the loop element. But what happens when you're reviewing a contract manually is that you're either following an Excel spreadsheet or a document when you're reviewing. And let's face it, no one's looking at two documents at the same time unless they're quite junior. The more senior you get, you will probably kind of memorize those rules and then review an agreement. And then if you've got 10 people in your team, you're probably all doing it to a slight variation. When you have an AI playbook, the AI will do the first pass of the contract for you. It will pick up anything that's inconsistent with your preferences. So an AI playbook is effectively a set of rules against which you will review an agreement, and it sets out your appetite. And that appetite might be quite rigid. It might be, this is what's acceptable. Liability cap must be at least 12 months of fees, or it could be a range. So ideal liability cap is 12 months, but my fallback is 6 months. Anything below 6, I'm going to need to escalate. I'm not going to be able to approve that myself. So these are things that you can automate with a playbook, because you're coding your rules against which you review an agreement, and then the AI is doing the lift in terms of pinpointing what's in your agreement that is inconsistent with that rule, and then it's flagging it. And you also have a choice with most AI review tools, certainly you do with our tool, where you can tell the tool whether to flag something that's inconsistent. So you just get a flag that says, look here, because that doesn't align with your preference, decide what you want to do. You might just say, I'm going to ignore it. I'm actually fine with that today. You might say, I'm not going to redline it, but I am going to make a comment so that the other side can understand my concern and then redline it themselves. I know that some smaller teams don't actually redline, they just red flag and then they send it back over to the other side that's maybe more well-resourced to actually perform the red lines. And some teams might go redline it. So you can ask the tool to propose a redline for you that you click apply on, and it redlines the agreement for you in order to bring whatever's in the agreement in alignment with your preferred position. And then you can escalate. So you can flag what needs to go to another lawyer or to another department. We're working on automating that workflow, but there are ways that you can do this, such as, for example, create an automatic comment that gets annotated into an agreement that says, for internal review, which is what we do in practice now, right? So in practice now, you would select something, you would create a comment, and you would say, send this back to risk for review. How playbooks work is that if you have a rule that says if you have an agreement that says that your liability is limited to 3 months of fees, your preferred position is that you want 12 months, not 3. The fallback is 6 months, and escalate if any other time frame. So if this is your third negotiation and they're not budging from 3, then you know that you need to escalate. And so it's very kind of process driven, whereas what we do with our heads when we're reviewing manually isn't necessarily always that process driven. Sometimes we go by instinct, sometimes we go by what we heard a colleague say yesterday. So just the very exercise of pulling out these rules that are either in your head or many different people's heads is a very good exercise for the risk profile of your organization, because you are immediately creating consistency. And I think that's something that we don't necessarily highlight when it comes to this. It's all about efficiency, automation, doing things more quickly, not being bottlenecks, but there's a big risk element here. And the fact that you're creating that consistency with the use of AI because you've got just one set of rules that you're all following, I think that's a big benefit of this process. Okay, as I've said, not all contracts are the same. So I was quite shocked at the fundamental differences between own paper and third-party paper and the mental processes that we go through when we're reviewing these types of agreements. So when you've got your own paper, you've drafted this, you own it, it's your language. And what I've seen in some organizations where their legal ops functions are a bit more mature is that they do have playbooks, and their playbooks are usually in an Excel spreadsheet where it says that this is the clause language. Do not accept any deviation to this language at all. So that's your first rule. Except if the deviation is to this bit of this clause, in which case strike out what the other side has put in and introduce this pre-approved language. So there are some teams that are so prescriptive about what can go into their own paper. I worked with a large fintech, and they had their own paper. They only contracted for their product, only contracted on their paper, and they had thousands of clients. And so they had to have this prescriptive element to the way that they negotiated agreements. And this was a huge kind of a governance tool, basically. So their playbook for own paper was a governance tool that we then took and automated. But it's a very different beast to third-party paper, because with third-party paper, you do not control the language, but what you can control is the outcomes. So yes, there might be instances where you say, I need to have this clause drafted in exactly this way when it comes to this type of provision. But generally, what you're looking for in a third-party agreement is to ensure that the outcomes that it provides are aligned with your risk appetite. So it's a much more outcome-driven risk assessment rather than a language-specific assessment. Does that make sense? Let me know if that wasn't that clear. But as I said, with own party, you control the paper. So you might have protections that always need to be enforced. You know exactly where those are. So when you're drafting your AI prompt, you have to draft it in a different way. You're taking a different structure to that prompt. So for example, when I'm drafting a playbook for own paper, this is how I structure my prompt. So I will say, ensure clause 1.2 uses the following wording exactly, and then you would put the wording of 1.2. If there are any deviations, reject. Now you might say, why would I bother having a playbook rule? Because I can just see where the red line is and I can reject it. The thing is that you may have instances in which it's just a hard line. You just have to reject the deviation because you're not accepting any changes to that provision. You want it exactly as it is because it's been through loads of boards and that's how it's been approved. But then you might accept minor deviations. So in the second example, you can say except where the deviation relates to the notice period, in which case accept up to 14 days. So here you're creating almost like a fallback where you're saying everything else needs to be rejected, but this bit here is acceptable. So you're controlling the flexibility. But what you're telling the AI is review the language in the agreement and make sure that it's word for word this exact language, except this small variation. And that's very different to if you're reviewing a third-party agreement using a third-party playbook, where you might have, you're telling it what's acceptable, what's tolerable or out of bounds. You're being much more kind of vague, not vague, but you're not being as prescriptive. You're giving it boundaries, but you're not being prescriptive about the language. So approved options, you might have, governing law is New York, Delaware, or California. You don't necessarily care about how that's expressed in a third-party agreement. You can't start being prescriptive about how the governing law is expressed. And so here you might have something that looks a bit more like this. The liability cap must be 12 months. If it's less, then accept. If it's more, if it's between 6 and 12, then that's your fallback. And if it's 6, escalate. So obviously this is not how you would write the prompt, but this is just an example of the outcomes that you're seeking. And then you might say governing law must be one of New York, Delaware, or California. And if it's any other jurisdiction, then escalate or reject. So this is, this is the difference between own party, where you're telling it exactly what language to look at, and third party, where you're telling it that these are the things that you'll accept and these are the things that you will not. So here's just an overview, because here's just a visual overview. So with your own paper, you have full control. You wrote it. You can go clause by clause enforcement. You can do the whole agreement if you like, or you can do just the ones that you're quite precious about, or just the ones that are more contentious because the others don't really ever get negotiated. And then with your third-party paper, you don't have any control over the drafting, so you're going for an outcome-based evaluation. And the reason this is important is because it will affect the way you structure your prompt. And just on that, I'm just going to pause there. Is there anything that I've spoken about that people weren't quite clear about? Yes, sorry, Murad, when I say third party, I mean vendor, or it's not your agreement that you drafted. This is not your template. Yes, Sam, thank you for sharing that. Yeah. Is there anything that I've missed here, Dory?
So I know you've sort of covered this, and I know that it is business and, dependent a lot of times, but is there a way to achieve an optimum level of granularity in your framework for your rules? Like, where do you draw the line between letting the AI playbook run and rules versus the decision to escalate to a human?
So the decision, this is the exercise of you crafting your playbook. Those are questions that you're going to be asking either yourselves or your team or your GC or your COO or whoever's responsible for this part, because you can let the AI run and the AI will do what it thinks it's best based on the LLM and any prompt architecture that sits on top of it. However, the way to really get the AI to do exactly what you would do if you were reviewing this manually is to be really clear about what you want from it. And that's not something that we're necessarily used to. Even when we're instructing juniors or when we're training them, we're often quite vague about things, and then you just expect the junior to come and ask you if they haven't fully understood, or just make their own decisions because they've had training. And but with the AI, the more prescriptive you can be, the better the output, which is why we've devised the ICA framework. The ICA framework is a great way for you to think about when you're to think in these terms when you're drafting a prompt. So I'm going to show you where you would draft a prompt and how to do that in a minute when I show you the tool. But if you think in terms of identify, check, act. So when you're speaking to the AI, it's good to tell it where to look. So if you're crafting a playbook for your own paper, you would say, ensure that clause 1.2 says this. You're telling it where to go. If you're drafting a third-party playbook rule, you would say, this applies to the choice of law of the agreement. So you're not pointing it to an exact clause, but you're giving it parameters as to where to go and check. You don't always have to put this bit in. I don't always use the identify bit if the second bit kind of amalgamates that. So ensure the governing law is California. You don't necessarily need to tell it that it's a choice of, that this applies to the choice of law of the agreement, because the second part kind of does that. But if you're talking about something that's more vague, then it's best that you point the AI in the right direction, because it makes it quicker, it gives it a lower lift, and it gives you more accuracy, which is more important. And then you want to tell it what to do. So redline the clause to specify California. So you're telling it exactly what to do. And here, this might feel redundant because you've already told it that you want it to be California, but it's not, because now you're instructing the AI as to what to do, and the AI will process this as a separate instruction to the second one, which is, this is what I want you to check, and now this is what I want you to do. So if you're drafting prompts and you follow this structure, it's a very effective way of getting what you want out of your tools. So for example, if you say something like, we're fine with any liability cap between 500 and 1 million, what the tool will now do is it will just, if it's neither of those, it will just apply whatever it thinks. Maybe it's 500, maybe it's 1 million. So you're going to get inconsistent results. Whereas if you say the liability cap must not exceed 1 million, but actually you will accept 500, if it does redline to 500, that might sound confusing, and that's not a way you would instruct a human, but you're giving it the upper limit, and then you're telling it what to do if it does exceed that limit. So you're giving the AI a clear condition to test instead of forcing it to interpret flexibility. So ensure the liability cap does not exceed 1 million. If it does, redline to 500K. So if it's 2 million, it will redline it to 500K, and then you might negotiate to bring it up to 1 million. But if it's 1 million, you might be okay with that, and so it won't flag it at all if it's up to 1 million. It's important to isolate one rule at a time. When customers use our playbook to create rules, I often see that they bunch 5 or 6 rules into one prompt, and that will confuse the AI, because the AI wants to process a rule and move on to the next thing. And then if it has too many things to do, it will take context from the previous things you asked it to do. If you're using ChatGPT, you might notice that as well. So if you're having a conversation with ChatGPT and then you ask it something random, it will take context from the previous content that it's either generated or that you've inputted. And often you'll think, God, you really misunderstood that. But then you realize that actually it's picked up context from your previous conversation. So the more granular you are, the more accurate the output will be. So try and keep one rule at a time. Even if you've got 3 ensures, ensure this, even if you've got 3 ensures that are relevant to liability, it's best that you split those out into different prompts and different playbook rules, because that will be easier for your AI to process. And then another thing is make every rule testable. So if a rule can't be tested against text, then the AI can't enforce it. So if you say the party must use reasonable efforts to deliver on time, it's going to be very hard for the AI to understand where that needs to sit. So if you say something like the delivery date must be specified and it must not exceed 30 days from signing, if you're more boundaried, the AI is better at processing that kind of prompt rather than something that's more vague and that doesn't necessarily tie to a specific part of the agreement. Obviously, there'll be areas where the party must use reasonable efforts to deliver on time, but it's very difficult, even if you're a human, to understand what that means in practice, unless you're a very experienced lawyer. Okay, so just to wrap up on the ICA, you should tell it where the AI should look, what condition to apply, and then what to do if the condition's not met. And if you structure all your prompts with this framework, it will work. Of course, sometimes reality doesn't fit the rules, and sometimes things aren't as straight and cut out for AI. So this is why we have fallbacks. So Law Insider and Simple Docs have just released a feature called fallbacks. And what you can now do is you can code in multiple rules against which the AI will check an agreement to tell you whether your primary rule or your other fallbacks have been met. So fallbacks will show the AI where there's flexibility, basically. So you can build in flexibility within your parameters. Because lots of contract positions aren't binary. You might have a preferred position, you might have acceptable alternatives. And so you can now encode that kind of structure into your AI. Now, one thing that I want to differentiate between is that you have fallbacks that are hierarchical and fallbacks that are multiple acceptable, as we call them. Where there's a hierarchy to your fallbacks, you will have a preferred position, then your second best, and then your third best, or your third position is like, we don't accept to escalate. But then other times you'll have multiple acceptables. So you may not care if the jurisdiction is one of these three, in which case you don't want the AI to bother you or to flag anything if it's one of these three jurisdictions. So I'm going to show you what that looks like in our tool. So here, this is the Law Insider word add-in. If you go into Playbooks, you will see that there is a way for you to build. Sorry, I've created, here's one I baked earlier. So if you go into the rules, I've got two rules here that I've created. So the first is term. So in order to create a rule, you would write out the rule name here. Here you would say what your preferred position is, and here you would say what your fallback is. So here I'm saying that I want the term to be no longer than 2 years. That's my preferred position. Here I'm saying 3 years, and here I'm saying 4 years. And I'm asking it to redline the agreement if it's not meeting my criteria. So if I save and run that playbook, you're now going to see what the fallbacks look like in practice and how you can tell with the tool how you can pick out your preferred position from your other positions. So because it's checking 3 positions now, it's going to take a bit longer than the other rule that I've set out here, which only had 1 position. So if you just give that a second, it's going to go and find term, and then it's going to check it against each of the positions that I've set out.
Electra, as this is going, we did have a couple of questions specifically to this, which is part of this is kind of as you're handling negotiations where there are multiple back and forths and you have a certain fallback that maybe you don't want to accept in a first round, would there be ways to, or effective ways of doing like a first round of fallbacks and then perhaps a second round negotiation fallback?
Yeah, so this tool doesn't know whether this is a first negotiation round or a second negotiation round or a third negotiation round, but hopefully the reviewer does. And so here, what this tool is telling us is that the primary position, your preferred position, is not met. So the term here is in fact 5 years. So my primary position has not been met, but it's telling me also that my fallback 1 is not met, so I'm going to go there as well. It's also giving me a proposed red line as well. So if you look here, it's just giving you the red line, and if you were to hit apply, then that would change from 5 to 2. And then it's also telling me that my second position has not been met. But if that was to change to 4, and I were to regenerate this might take a minute, but it would tell me that my third position has been met. So that's how you would build out your fallback. So you won't be able to rely on the tool to tell you what round of negotiations you're in, but you can rely on your fallbacks here to be coded so that the reviewer knows which one they can apply. Sorry, I don't know if that answered the question.
I think so. And then can playbooks, I would say probably the Law Insider ones specifically, refer to other documents? So can your playbook specify that a statement of work must be consistent with the master services agreement?
Yes, totally. Well, you can ask the tool to verify whether the statement of work is consistent with the MSA. It's not necessarily the focus of today, but there's a compare function here where you could upload any document and ask it to review that document against this document and give you a set of differences. And then you could also ask the tool to redline the agreement to bring it up to scratch.
Great.
If you're going to use that as a quasi playbook, I wouldn't rely on it entirely because it's not doing a rule, it's doing more of a direct comparison rather than looking at the nuance and you know, what your preferred positions are and the fallbacks, etc. So yeah, but you definitely can use it for that use case.
Great. While you're here, before you jump off, do you mind showcasing quickly, is there a technique that makes an AI flag and fill in gaps in third-party paper? So sort of somewhere between a playbook and a template. So probably the general view. Exactly.
Yeah, so you can use the general review. So the general review, what it does is it first asks you for some information. So which party do you represent in this contract? And do you have any specific concerns? You can go fast or highest quality. I would always go highest quality, but if you're in a hurry, which I am, I'm going to go fast. And what this does is it then starts off by giving you a strategy summary. So this here will tell you what it's planning to do. And this is to give you an opportunity to go through the key points that it's raising and iterate and add to it, or say, I don't agree that there should be mutual indemnity. It should just be one-sided and it should be on the vendor. But once you're happy with that, you can say start review. And what this does is it creates a playbook based on those rules that it's told you it's going to create a playbook against. It's not told you that it's going to do a playbook, but that's what it's doing. It's creating a playbook there and then. But this is not based on your exact preferences. It's based on the LLM's knowledge and the context within the agreement. So you will get a playbook, and this is a great way of reviewing a contract that maybe you don't review volumes of, and so you don't want to have to do a playbook for, but you can get a general contract review that's LLM driven, not necessarily your preferences, really quickly. And this is what it looks like.
And then one more here. So as negotiations progress, section references might change. So for example, clause 2.1 may become clause 2.3 if new provisions are introduced. Is there a solution for this when instructing AI where to look?
That's a really good question. I think that if it's your own template, then you can structure your prompt to give it that flexibility where you would explain that within your prompt. That might need a bit more prompt engineering there. So if you're partnering with a vendor, they'll help you structure that. But I think that what's important to note is that your playbooks are live documents themselves. And so you would have to make sure that you're always updating them. So if you've changed your template and now 2.1 is 2.2, then you would need to update your playbook so that you don't get any confusion that occurs. But yeah, as you're reviewing an agreement, if that document is changing and you're adding more numbers, the playbook should be smart enough to realize that there's a mismatch there and it would flag it for you. But yeah, that's a really good question.
Great. And then when you're creating your playbook, do you generally insert pre-approved language or clauses in as your perhaps either your note or your actual red line, right? You would be able to define what you would want that pre-approved language to look like.
Yeah, I mean, I think that it depends on your organization and your risk appetite. If you're happy with, because at the end of the day, we don't want to be doing red lines for the sake of red lines. So if you're happy to go with the principle rather than the exact language, then go for that, because that means less red lines. The purpose of all these tools, in my view, at least, is to reduce the time that we spend on negotiations. So I wouldn't want to see AI being used to red line because it's easier, and so as a result we get more red lines. And so if you can accept a principle, the AI is really good at detecting that. Don't worry that the AI won't be able to detect a principle, and therefore you need to be more prescriptive by giving it exact language, I think is the answer to that.
Great.
Cool. Unless there's anything else, I'm going to move back to this. Okay, so we've talked about fallbacks. Then, yeah, the importance of testing. So if you're working with a vendor and they've delivered a playbook to you, so with us, if you have the playbook feature because you can buy the tool without playbooks at all. So you're just using the AI assistant to query the document and create memos out of the document, or redline very specifically, or draft new language. You can have that version of the tool, or you can have the version where you also have playbooks. If you have playbooks with us, we will always work with you to create your first playbooks and train you on how to use them and create more of them. So if a vendor's created a playbook for you and delivered it, then the next bit is for you to test it. So don't think that that's the final version. You should be testing it, making sure that the AI works as it should, or, having said that, expect that it won't in certain instances. And so you would need to give feedback to the vendor to update your prompt, or ideally you're comfortable enough going into the playbook yourself and creating a prompt that works for you, or iterating on the prompt and then refining it and repeating it. And the more you evolve and the more contracts you review, you'll realize that, the AI is not necessarily picking up something that you want it to pick up. And so you go into your playbook and you introduce a new rule. And as you go along, if you're using this for a year, you can expect your rules to double, because as you're reviewing and you're picking up things that the playbook did not, it's got nothing to do with the AI. It's the fact that you didn't tell the AI to look for that thing. So this is organic, is the message of this. And when you're creating your playbook, just make sure that all your high-risk clauses are covered. That's what you want to start with. If you haven't got a playbook at all, you can just start with 6 or 7 rules that are really high level, and then you can build organically from there. You've got your fallback logic. So do you know what your preferred positions are, your fallbacks? This, again, it's a great opportunity for you to have these conversations with your team. And yeah, did you try and deliberately break your template, and did the AI catch it? So when you're testing your own paper playbook against your own paper playbook against your own paper, you want to doctor your own paper and put things in it that are not compliant with your rules, and just make sure that the AI is catching it in the way that you would expect. If not, iterate on your prompt. Again, you can take any third-party agreement and run it through your playbook. You'll probably never get one that aligns with absolutely all of your rules, so that's easier to test in a way. If you're not getting the results that you want, just check that your prompt is following the ICA format. And yeah, if you have anything that needs to be escalated, just make sure that you have the right thresholds in place to ensure that escalations are happening only when they need to. Now, this is, a very frequently asked question, and I try to answer it at the beginning, but yes, you can create playbooks from templates, but they will never be as robust as playbooks that are created from scratch. They will eventually become as robust, but there's work that needs to be done. So what I'm trying to say is, just because you have a template, that's not a silver bullet for an automated playbook. There's work that needs to be done on both sides. If you're working with a vendor or if you're doing it yourself, there's work to be done on both sides to make sure that that's happening. And the reason is that when you have a template, your template, say you've got an NDA template, it's got 5 clauses in it if you're using one NDA. Those 5 clauses will only say, 20 things, because they are telling you, if you're trying to use AI to extract the principle that underpins that provision, it's giving you the principle of the provision that's in there. But if there's no non-solicitation clause in your NDA, because you don't think there should be, rightfully so, you can't expect the AI to guess that. So the AI will not know that the absence of a rule that may or may not be found in that agreement should be a rule that gets applied in your playbook. So if if there's something that's not in there, that means that you don't want that in there. So you know that you need to create a rule that says, if there's a non-solicitation clause, reject it, redline it, delete it. Just by feeding the AI a template, you will not be able to get that nuance. So absence equals a rule, but the AI doesn't know that. So that's why you will never get a great playbook if you're just relying on a template, because the AI will not be able to guess those things, which is where you would come in and fill in the gaps. Or if you're working with a vendor, that has done loads of playbook work, they might say to you, what about these clauses? They're not in your template, but do you want to include them as negative rules, right? And it's quite gimmicky to some extent. I mean, we do it. You can upload a template to our tool and you can create, I'm going to show you how to do it now. This is a good start because it gives you a starter for 10, and often the problem is the blank page problem, that you don't know where to start, but you can just use our AI to start something that is going to give you a starting point. So this is what our tool does. So it asks you, which party are you representing? And then we go with fast because we're in a hurry. And again, it does something similar to general review. So it gives you the strategy summary. It's going to go over the key points that it's finding. But what it won't do is find anything that's not in here, as I said. The other thing that it won't do is that it won't be able to guess your fallbacks. So if your term here is 4 years, then the AI will think that 4 years is that's your rule. But actually your rule might be, I'm okay between 2 and 4. But the AI won't know that. So if you do create an AI generated playbook, you will have to tweak it. And then from here, you can just go generate playbook and it will start to generate your playbook. And then from here, you can go in and start to add your fallbacks, tweak it to ensure that the position that you expected has been properly captured. So this is a good way to start. What this doesn't do yet, but I am working on making it work so that you at least have a starting point, is create playbooks for own paper. So this only does third-party paper at the moment, or own paper if you're not too precious about how prescriptive the language is. So soon you will have the opportunity to choose whether you're building a playbook for your own paper or third-party paper, whether you want to be prescriptive with the language or not, and then you'll be able to create a playbook, which again will be a very good start, but not the final thing.
Electra, sorry,
Yeah,
just
go ahead.
interrupting you here quickly. Is it possible to give AI an instruction that there should be no clauses other than those covering topics A, B, and C? Or at least these should be flagged, rather than giving like numerous negative rules?
So it depends on what the substance of that clause is, but generally it's not best practice to structure your prompt that way. So you don't want to just let it guess what it can eliminate. You need to be really clear about what you want it to eliminate and where your boundaries are. It's very good with negative rules. If you give it a positive rule, like this type of liability is acceptable, then it won't have anything to flag. So you want to tell it what's not acceptable in order for it to flag it. Sorry, here's the playbook that it's created. So there are 25 rules, which is pretty good for a 10 clause agreement. And then if you go into it, you can go ensure that all services to be provided are described in one or more statements of work that are expressly incorporated into the agreement. Cool. You might have a fallback. You can just add that here. You can enable comments. This is not something that we do automatically. We don't automatically enable comments, but if you wanted to include an annotated comment automatically whenever you redline where there's an inconsistency with this rule, then you can add that comment here and then you would save your rule. So yeah, that's the way to generate an AI playbook, but then just to be clear, there's work to be done afterwards to bring it up to scratch.
Great. If you don't have specific rules on certain clauses, would you suggest having AI propose some options, or is that something that you would trust?
I mean, the AI will do what it thinks is best practice. That won't necessarily align with your preferences. So I would prefer that you think about your rules and what you want the AI to do. So the AI is, you can ideate with AI and ask it to give you ideas as to what it is that you should be picking up. If you're going to do that, then you're best off just using general review. If you're using the Law Insider word add-in, I know that not all tools have general review, but the best way to get a playbook to work for you is for you to tell it what you want it to do and to be as prescriptive as possible. And often that's the hardest bit. Like, what is my rule? I don't know. That's the bit that's that needs thought. Right, if anyone's got any more questions, please put them in now so that I can respond to them. We've only got 10 minutes left. So yeah, I'm just going to start to wrap up now. But as I said, any questions, drop them in now. AI does not replace lawyers, it amplifies them. Lawyers are architects, so our role is going to start to shift. I did a webinar about our shifting role, and I'm very interested in this topic. I think we're about to witness a change in our profession, which is very exciting. We're going to be architects, we're going to be designing the playbooks, we're going to have to translate to the business what a rule means. I know that if you have reviewed contracts for years, like I have, you will review a clause and you will get frustrated because you're thinking, this shouldn't really be my decision. This is a risk decision. This is an IT decision. This is a finance decision. Why is it all being given to me? So the opportunity to take all those rules and codify them and get other people in the business to sign off on those rules is a really amazing quality control, risk control tool that you should be leveraging. And I think that is what our role is going to be elevated to. We're going to be the architects of these systems and the designers. And over time, we will be spending less time on line by line review and more on strategy and negotiation. What's our negotiation strategy? Imagine in 3 years' time, when everyone's really comfortable with playbooks, we all know how to prompt a playbook, we all know how to get the most out of our AI. We're going to move to the next stage, which is, well, does this make sense? Is this getting us the least rounds of review as possible? Because you don't just want to automate bad processes. You want to optimize your processes and then automate them, because actually you could be doing more harm than good if you don't go through that process. And a lot of us won't. A lot of us are just trying to upskill now and get stuff that's in our heads into a playbook. But once you've nailed that bit, which you will, the next stage is strategy. It's, does this negotiation work for me? I've got these 3 fallbacks, but I'm always falling back on fallback 2. I should make that my primary and save time for the reviewer and save, the back and forth with the other side. So we're looking forward to that bit. And if you think of yourself as a playbook architect, the AI does not invent policy. I would not rely on it to give me my preferences. It will enforce what you design. So I think that is where the lift lies, in you codifying what your risk tolerance is, your fallbacks, your escalation triggers. These are the bits that are going to require the heavy lift. The AI does a really good job. The bit where it fails is in implementation, and it's because we're not giving it the rules that it needs to do the right thing. And yeah, it's, if you think of your playbook as strategy, it's not preferred clauses, it's not clauses library, it's your strategy that's turned into rules that you're then codifying, and you can really extend your capacity within your team. And yeah, just to remember that playbooks are never done, they evolve through testing, iteration. We're here to validate the outputs and make sure that the playbooks are doing what they need. Okay, we've only got a few minutes left. I will be circulating these slides. So if I see some questions that are coming in. Dory, do you want to let me know which ones you think I should focus on?
Yeah, there were a couple of questions that were earlier, and I didn't want to kind of detract too much. But is there a good method that you would suggest for efficiently cascading playbooks from general to more specific?
Yeah, okay. So, I mean, I think it's good when you're starting off with your playbooks to start with the one that's causing you quite a bit of pain, but isn't too complicated. So start with maybe not an NDA, because lots of people say NDAs, they don't take me very long, so I don't necessarily want that to be my first use case. So maybe go with a vendor agreement and start there. And then you'll find that you might have a DPA annex that comes into that agreement. So you might run your vendor agreement playbook and then your DPA playbook, and then you might have some general rules that you want to ensure apply to all of your agreements, in which case you might have a general commercial playbook as well. So many people don't know this, but you can run multiple playbooks across the same agreement. And yeah, you can have very specific playbooks for DPAs, or you can have really general playbooks as well.
going back to own party and third party paper, why
Yeah,
would you not take the same principles based approach to own paper as well from an efficiency perspective?
you totally can, but most people that I've worked with on own paper don't want to. So if you're happy with the language of your own paper being completely changed, but the outcome is the same, brilliant. Don't take the own party approach. But most teams that I've worked with, and maybe this is just, maybe I've got a biased view because I've worked with teams that are quite mature from a playbook point of view, and maybe they were larger companies that were consumer or not B2B facing, with loads of thousands of agreements that they were signing every day, and they had very clear parameters around what they can and can't accept in terms of deviations to their paper. So if you're that prescriptive, there's a different method. If you're happy with totally deviating from your language but having the same outcome, then you can still take that approach, and it definitely is more efficient, Sophie.
Great. And then within the add-in, are we able to distinguish between comments that were internal and comments that are to the other side? I don't believe so, right? There are comments and
Just comments. Yeah.
right.
But if you tell the tool, comments from Teresa are this, but then comments from are this, then it will be able to pull out who's.
Great. What is our current level of or degree of confidence in the output of the review tool?
So we have a very high degree of confidence in the output when you have a playbook. So when you've told the AI what to do, it's really accurate. It will do what you ask it to do, and often it will do it in a way that you didn't necessarily envisage, which is even more effective than had you drafted it manually. So yeah, the confidence level's high. We do live demos we do them twice a week, I think, Dory. So if you wanted to come see that bit in action, please feel free to join one of our demos. Dory, maybe you can drop a link to the demo here. So if anyone who wants to see that in action, you can come along. I love this one. Similar to the standardization of one NDA, are there publicly available AI playbook templates that companies can use to get started and then customize to their own needs? We have lots of standard playbooks in our tool that you can use to start with. But yeah, that's a really great idea, and we should start to crowdsource that in our community. We have a community forum if you're interested in joining. Dory, I don't know if you can drop a link to Circle here, but we should start thinking about how we do that. But for anyone who's using our tool, if you go here, standards, these are actually, so this is based on one DPA, these playbooks here. And the mutual non-disclosure agreement is based on one NDA, and this is based on one SAS. So we're releasing more, by the way, not standards like one NDA and one SAS just yet, but we're releasing more playbooks as we speak. So there'll be even more here for you to use. But these are standard playbooks that you can just take off the shelf and just use them to review an agreement of that type.
Great. Well, hopefully we've gotten the majority of the questions. I do apologize if anything wasn't answered, but I do think that we've touched on just about every question that has come up. And so I think we are right on time here, Electra.
Amazing, thank you. To anyone who wants to see anything more specific when it comes to the realm of AI and usage and practical webinars like these, please do feel free to let me know. Do feel free to reach out and let me know what you think you'd like to see. So yeah, I'm always really open to suggestions, and we want to be giving you stuff that you can use. So yeah, thank you. Thanks everyone. Thanks for joining.
Thank you.
Thank you. Take care, everyone.